really looking forward to talking about the legal tools for research data, how they can act as barriers, how they can act as bridges, when you want barriers, when you want bridges. So let me take care of the mechanics here and share my screen. And you are seeing the wrong screen. So I'll fix that. And now you're seeing the correct screen. All the better. All right. So thank you again. So today we're covering the tools and resources available for you to make decisions about your research data and all of those other research materials that are associated with your data with regard to use agreements, security requirements, copyright, licensing, all of these pieces that exist with them that can help you with appropriate sharing around research data, with protection for the research data or other research materials that you're producing. So please set yourself up as you know how to do on Zoom. Put your name in there, put your preferred pronouns. We are going to be doing a presentation via PowerPoint today. And I do encourage you, if you have a question, please put it in chat. We will be monitoring chat. There will be some times when I go ahead and pause and ask for any questions. And if you have something you'd like to say, it's okay. Go ahead, unmute yourself. Feel free to speak. Be aware this is recorded. So if you'd like to chat instead, that's all good. Also, as we share our screens, you know that you're able to make the slides bigger so you can see them better within the Zoom interface itself. And I know AJ has already put the links to our slides in chat as well, so you can open those up and use whatever viewing tools that you may need to see those better as well. So let's start out. First of all, I'd like to say hello, and I would also like to offer AJ an opportunity to introduce herself. AJ?
Hello, everybody. AJ Tornator, also a member of the Data Management Services Group within the library, is working with Amy. Thank you.
Thank you, AJ, for that. So I think first thing out there is to really clear this up, although we are going to be talking about legal tools. None of us are lawyers. So none of this can be construed as legal advice. This is just based on our experience and expertise as members of data management services at MIT and which are situated in the libraries. If you're interested in what you hear here or have other questions about services around research data and its management, please feel free to reach out to us and we'll be happy to help you however we can. So today we're going to be covering 6 different areas. First, we want to clarify what it is that we're talking about when we're talking about research data, how privacy and participation impact how you're going to be managing that data, what kind of tools you're going to use around that data and those materials, so how security and sharing play into this space in terms of what you have to do, what you're obligated to do, what you have other duties towards as far as risk management, mitigation, how those legal tools start coming into play in terms of some of the ones you might be familiar with around copyright, licensing, and use agreements. So let's dive right into this. First of all, data. As you've already noticed, I go back and forth. Sometimes I use data as singular, sometimes I use it as plural. I really apologize for this if it irritates you. I'm really sorry. I will continue to use it both ways, probably indiscriminately, and I ask for your forbearance on that, because what we really care about is the fact that we have data. And the problems that we're dealing with are more challenging than whether we're going to use it singularly or in a plural sense in these settings. So first of all, what is it that we're talking about when we're talking about data? First of all, there's there are facts, right? A fact is a thing that happens. It's known to have happened. It can be distinguished from opinion. It can be distinguished from other structures. Data is a specific subset of fact, where it's an observation about the world that's collected within a research setting or some other structured mode by scientists or by others, and it has a minimum of contextual interpretation. When we talk about research data, it's even a smaller subset of that. And we're looking there at the really what we've been given as the legal definitions from the government. So this is from the that research data is defined as the recorded factual material commonly accepted in the research community as necessary to validate research findings. So really, we're really drilling down to what we're talking about in this space when we're discussing research data and associated research materials. So what I'd really like to highlight here in this definition around research data is that it is commonly accepted in the research community. So community plays a large part in defining what is in fact necessary to validate those research findings. And we can see here that it can mean data in all sorts of forms, right? It's facts, it's observation, it's images, and it's also the materials that are necessary to understand and use those facts, those other materials that are collected. The data can exist as numerical, it can be descriptive. It may not even be something that you think of as data as such. It could be very much, just a basic text. It can be scholarly information. It can be a physical model. It can be raw, it can be processed, it can be all of these things. And this definition in particular is taken from the MIT Open Access Task Force definition. So it's one that's loosely used around MIT as what it means when we're talking about research data. But it really comes to this idea of all of these things can be used to support those research findings, but they can't be used alone to support the research findings. So it's not just that table of structured data. It's not just that picture. It's not just that map. It's also all of those other pieces of supporting information that bring meaning to those pieces of data. So that could include the tools that are used, what is the descriptions of the tools that are used, how the data was collected, and other pieces of contextual or supporting information. So examples of these include analysis scripts for your tools or algorithms. It could be software that was developed as part of the research endeavor. Models, language models, machine learning models fall into that area of tools as well. That's a necessary part that's encompassed by that idea of research data. It includes the metadata, and that is, of course, any information about that data above and beyond the data itself. So it could be instrument settings, it could be patient information, which we know has to be protected. It could be conditions at the time of collection. And any of that documentation around it. And then there's also the other supporting information associated with it. So when we say survey instruments, we're talking about like the surveys themselves, right? Those types of things. It could be data dictionaries, it could be code books. So I'd like to take a minute and pause and ask you to make use of chat for some of the examples of research data that you've seen or that you've worked with or that you've had occasion to play about with. And please just go ahead and put those in chat so we can get an idea of where we are with this. Or are there particular types of research data or research materials that you're interested in working with that maybe that you work with or with groups that you work with, you know that they're producing those types of materials that you're going to have specific questions about? Yeah, you're absolutely right, Stephanie, about the medical applications and research. There's so much that falls into this space, everything from the particular patient information to thinking about how that information is being collected. And again, survey instruments play into that space as well with specific tools. So certainly open source data sets and software tools are a big place where we're thinking about what open means. Is there just one big wide open of openness, or are there qualifications around what openness looks like to whom? And we can talk about different ways that legal tools are used there. So thank you for that, Jordan. Any questions about the definition of research data or research materials before we move on? All right. So now that we've cleared up about what we're actually talking about today, and that's research data, which is that narrowed definition of facts in general, I'd like to take us into this space of thinking about where we actually need to establish barriers for protection, right? So what we're talking about today is legal tools for barriers and bridging. So we're going to start off by thinking about what are those spaces that in fact need barriers, need protection, and how we can successfully allow bridging into places as well, while keeping in mind those characteristics of protection. So the first thing I'd like to talk about is privacy versus security. So when we're talking about privacy, it's really about what is the appropriate use of data? Who should be using these pieces, these research material, these data, and what should they be used for? Are there appropriate uses? Are there inappropriate uses? Being able to assess that. While security is really about the actions and implementations that enforce, that ensure the privacy decisions that have been made about those particular research materials. So you can have privacy and security. You can have security without privacy, but it's much more difficult to have privacy without security. You can say you have privacy, but if you don't have the security to enforce it, the privacy is pretty much meaningless. So what are some of the ways we think about privacy when it comes to research data? Well, privacy is really thinking about who should have access to what data when. So for these places, thinking about who are the research stakeholders in these spaces, who who has who should have the ability to see the research materials, who has some part of ownership or duty of care or stewardship responsibility to the different data pieces. And we might think of this, well, certainly if you're dealing with to the medical research that Stephanie mentioned before, you have the participants in the research. They certainly are a stakeholder in the research, right? If you're dealing in a medical health setting, quite possibly you're being funded by the NIH or HHI, someone like that. So we have our funders who may have a stake in the research and the materials that are produced through the research. Again, going back to NIH, government funding, that means we have another body of stakeholders in this space, and that's the taxpayers, because there's a certain duty to the people who paid for that research going all the way down. You might also be sponsored by industry, so there's going to be that set of stakeholders. There's the research community itself, because we know research is not done in isolation. Research builds on other pieces of research, and it's only through sharing and building on the community work together that research itself is able to grow and extend. So we have the research community. And of course, that's in addition to the researchers themselves, who are obvious stakeholders in the process as well and in the materials. So one of the structures for thinking about stakeholders is, you may be well familiar with the acronym FAIR, which stands for findable, accessible, interoperable, and reusable, which is a nice, concise description of goals that we often have for research data. We would like it to be these things, generally speaking. But going along with that, there's another acronym called CARE. We're thinking that we like to think about. And as much as FAIR is important in the space of research, data should also be about the human aspects of this. So FAIR was originally created with the mind of machines exchanging the research data as information. CARE really brings that human aspect into it. It was developed by the Indigenous data sovereignty community in recognition that good data practices have to go beyond machines to the humans who sit with the data. And with their permission, we've adapted it in this space where we're thinking about what it means to develop and create data structures that do provide collective benefit to the communities and the stakeholders that we just talked about, that think about who has the authority to control the data. And this is really where we start getting into that tension between barriers and bridges when it comes to thinking about research data and research materials, thinking about the responsibilities associated with data. As you may be a researcher, what is your responsibility to the data? What is your responsibility to the other stakeholders within that research ecosystem? And then what are the ethical aspects that are intrinsic in those spaces in that research as well? Now, of course, having these practices, these platforms, policies for thinking about research data, research materials to make that fair data sharing feasible means that it also has to support some of those other legal requirements, such as GDPR, along with the moral imperatives of care. Of course, the alternative is to, not care about our research, not care about our data or about our participants or thinking about those things. So when we're talking about privacy, we covered about who should have access, and it's to what data that should they have the access. So we already talked about all of these different things that might fall into that space, into that scope of data. And we're familiar with what those legally protected data elements are within the US context, right? We have those social security numbers, we have personal health information, we have, the protected health information, the personal identifiers, things like that. And along with that, we have other sensitive information that also needs to be protected. Now, and again, this is just within the US context. As we're seeing more and more, other countries are establishing their own structures for data protection. At this point, we're probably quite familiar with GDPR, which is the EU's structure there. We're becoming more familiar with China's, which is the PIPL. And we're seeing other requirements come out as well, whether that's from Brazil, or from specific states within the US, such as California, who have their own particular data requirement protection laws. So at MIT, the way we approach this is through this idea of risk management. When we're thinking about what are the requirements for different types of data, what is the risk that their exposure might lead us to? And so we have a very low risk level where the information, it's either public information already, or it's not like it would cause harm, but we've just chosen not, in fact, to disclose it. We also have the medium risk level, where, the information really isn't intended to be freely available, and it could cause issues of liability, reputational damage, or potential for other types of harm if that information were exposed. And then we have those very high levels of risk where it's absolutely subject to legal or regulatory requirements. Here we're talking about HIPAA type stuff, the things that have security classifications, those types of materials where the loss of security around them really has meaningful harms to all sorts of stakeholders in this space. So again, when we go back to thinking about privacy and we're thinking about who should have access to what data and when they should have it, it really keeping in mind that those privacy, that when aspect is because those privacy risks change across time. The risk doesn't hold constant at all points in the research process or at all points across time. Time changes risk. whether you're thinking about the stage of the research that you're in, that those materials in, or distance from the research or events in question. So, one example is there's often a lot more risk associated with raw or unprocessed data than there is with data that's more processed, where the individual granularity has been obfuscated, right? So thinking about that in terms of time and processing of data is going to change the amount of risk that it's exposed to. Another example of this is if, say, you're collecting interviews from a sensitive population for something like this, or a population that was that had some risk in giving you that information. That risk is going to change with how many years you are separated from that event, as generally the risk decreases there. So what we're really thinking about is how to create a balance between the stakeholders and their interests versus the risk we have around our information, our data, whether that's a risk of re-identification, a risk of de-anonymization. Thinking about privacy is not so much, the point is to eliminate all risks, because that's pretty much impossible, but really to recognize that risk to be able to manage it successfully. So thinking about, what are in that space, going back to what are the legal tools that are put in place to protect privacy, to encourage us to enact security, thinking about those laws that exist for those issues of privacy. And so we have strategies around how we implement security to serve those legal barriers that have been put in place. So you always want to be aware of exactly what data you have. What is it that you're dealing with, so that you can appropriately assess the risk that it might expose you to. And that's the first step there. And we have resources for that. Certainly within data management, we help you with understanding and organizing your data so that you do have you do know what you have. Being able to understand your data sensitivity. So we went through some of those data through those definitions before, where we were looking at the different risk levels. Those were taken from the MIT's Info Protect. And I would recommend, if you're not familiar with it, please do check it out. They have put in some more tools to help you identify the classification for your data, again, so that you know what level of risk you're at. And they also provide tools for implementing security practices around that data. I think they've also just put up they've just contracted with some instruction around basic security as well. So that might be something that you're interested to check out on. If you're dealing with sensitive data, would suggest using the Spirion tools, which can scan your data for sensitive numbers, such as credit card numbers, social security numbers, phone numbers, those types of things. But most importantly, you want to think about what data you're collecting so that you can manage it effectively. Only be collecting the data that you need in these areas, and thinking about how you're managing it through those so that you can meet those barriers to sharing that have rightly been set up through our legal structures to protect privacy. Some of the other privacy resources I would point you to is, again, the secure IS&T secure computing, as well as InfoProtect. And there are there are also tools available there. If you're looking for guides around confidentiality, such as anonymization or de-identification of your data, ICPSR has some nice tools there as well. And of course, if you ever experience a data breach of any kind, please reach out to InfoProtect. So any questions around, before we move on, questions around, some of the barriers that exist within the legal framework around data sharing in terms of privacy protection? All right. So now that we know that barrier of privacy, we can talk about how to work with it well. What are the tools that we have to work with implementing security, enabling sharing, while still respecting the legal structures that are required by privacy? So we're thinking about implementing privacy choices, thinking about how we support scholarship in these different ways and fulfill those requirements. So something to keep in mind in this space is this mantra of you want it to be as secure as necessary, you want to meet the requirements, you want to manage your risk, while at the same time making that information as open as possible so that we as a collective community can continue to support research, its growth, its development, and its advancement. So thinking about those things, there are a lot of different security practices you can put in place in order to make sure that you're complying with the privacy requirements, whether you're thinking about your operating system, things like that, you're thinking about physical security, you might consider encryption. All of these different tools exist for you, and you can access them again at the Info Protect. And we can also help you with data management services and backups, as well as secure computing. One of the reasons I mentioned backups is that there are different ways of experiencing data loss. You can, of course, experience data loss to someone else. You can also experience data loss where it's just gone. And that's not really fun for anyone because it often means you have to go back and redo the work, which doesn't lend itself to risk management either. So thinking about this, what research data should be shared when we're thinking about sharing our research data? Well, what the funders say is that, again, we go back to this research data is defined as recorded factual material. That's the stuff that should be shared, the stuff that your research community says is necessary to validate your research findings. Now, this does not include preliminary analyses. It does not include notes to yourself. It doesn't include the plans for your future research. So when we're talking about research data and even the newly defined scientific data that you find in the NIH data management and sharing policy, it's not getting down to that nitty gritty of, oh my goodness, we're going to have to share every single note that has ever come out of our research or lab. But it is something I would encourage you to think about when you're thinking about sharing, that we need to share enough information so that we can build on that information, so that we are supporting those ideas of reusability and reproducibility. We're thinking about how the information, the research materials that we're sharing can benefit ourselves and our own groups. We want to be able to share those materials with ourselves, with our partners, with our stakeholders in the research endeavor, as well as beyond that. So thinking about how what you make becomes the foundation of research for the future, because we want to be able to trust each other and base new experiments, new ideas, new ventures on what we are doing. So thinking about how to do that successfully. So questions about this point about thinking about how, laying out the groundwork, research data, what we're talking about, what's absolutely necessary in terms of barriers when we're talking about privacy and the legal requirements for privacy, and then what we might want to be accomplishing in terms of bridging, in terms of sharing, things like that. So now that we have this groundwork, any questions? All right. I'm trusting that there are no hands popping up because I can see the chat, but I can't see the participant hands. Okay. So more resources for you. AJ's doing a great job continuing to put the link to the slide deck, so you can get to all of those links if you need to refer to them again. Thank you, AJ, for that. So let's get into some of these tools, right? Okay, first up, copyright. How do we share data? So no matter how we end up sharing data, in order to be useful, we need to let people know how they can use that data. And this is where our legal tools really come into play in terms of what barriers do we want to erect? What bridges do we want to build when it comes to thinking about our research data? And the first tool in our box is copyright. And then we'll be talking about licensing and then use agreements. These lay out the conditions under which we share research data and some of our associated research artifacts and research materials. So quick overview, copyright, USA, facts are not subject to copyright. That's all there is there. However, copyright does apply to all sorts of other materials that we do produce in our research, right? When we go back to that definition of research data, right? Sure, it's talking about the facts and the observations, but it's also talking about the descriptive materials, right? It's talking about the software, the models, the other parameters that are part that. And in addition to that, you can note that different intellectual property rights can be associated with different elements of that research package, and they can be managed separately or distinctly from each other. So it's not like, we say, it's data, copyright doesn't apply to any of it. No, that's not right. The factual parts of your data package, uh, you know, copyright probably doesn't apply. How, generally speaking, there are other conditions. This isn't that talk. There's another great session that has been recorded yesterday that covers copyright, I believe. But when we're talking about those other materials within that larger conception of research data, of research materials, there are definitely areas where copyright comes into play. And what these are, right? When we're thinking about analysis scripts, when we're thinking about those code books, when we think about survey instruments, all of that metadata, the description that's generated around your research data, around your research materials, all those expressions and visualizations of data. This is where copyright starts coming into play as one of those things you consider that can act as a barrier and that you can manage into a bridge, right? In thinking about how you want other people to interact with your data, how you want to signal to other people how they can interact with your research data, with your research materials. So if you, when we're thinking about copyright, that could apply to research data that's produced, different parts of it that you yourselves are producing, that your partners are producing. It could also apply to research data that is sourced from elsewhere that you're bringing into this project that you, in fact, are reusing as part of your research. So it can get a little complex about which rules apply where. So like I said, there is another IAP course from TLO around the basics of copyrights. And I think, Stephanie, that was yesterday that was. Anyway, it is on the schedule and Stephanie has it, and I'm sure she'll put the link in chat if you're interested in there, or there will be a recording available for it. There's
Yes,
also,
it was yesterday.
it was yesterday. You just missed it. But again, recordings, they will likely be available. We also have a source within the MIT libraries for scholarly publishing around copyright if you have more of those copyright questions. So one of the other tools we have available to us is licensing. Like I said, copyright can be complicated, which is why licensing can be useful as well. Licensing communicates how something can be used effectively, right? While licenses are legal instruments within the realm of research data, I've generally seen them be more useful as indicators of how something can be used. So if you have, say, there's a research material, there's a data set, whatever, swimming around out there in the internet ether, without a license, a responsible researcher will look at that research data code, whatever, and say, I would really like to use this, but I don't know if I can. I don't know if it's permitted. I don't know if there are other conditions associated with its use. I better just leave it alone, right? I better back away, find a different resource, find a different set of materials. Which is a real tragedy, especially if the person who originated that material was like, yeah, no, I really want people to use this. I wish they would. I don't know why they don't. And it's we don't get that reuse. We don't get that efficiency in research. We don't get that rebuilding because of confusion, because of a lack of clear licensing, of clear permissioning around the materials themselves. For a lot of research data, the most common ones that I see generally tend to be in the flavor of a public domain release, or something along the lines of, I retain copyright, but you can pretty much do whatever you want. So, but you have to give me credit. that you got it from me, right? So these appear as like CC BY license is one of the more common ones. A CC0 license, public domain license, lets people know that you're not exerting copyright claim in these spaces. There are similar types of licenses as well for software and other materials. But before we get too far into this space of licensing, I do want to remind you the first thing that you need to do whenever you're thinking about intellectual property, licensing, those types of things. If you're at MIT, please contact the tech licensing office, because they are absolutely the experts in this space. They are here to help you figure out how to best communicate what use can be made of your materials, what use can be made of other materials as well. So please reach out to them. And this is how you reach out to them. So again, go back to the slides. They have all the links. If you're thinking about intellectual property stuff, please reach out to TLO. So like I said, if you're thinking about that, one of the most common licenses I see in this space, one of the most useful ones is a CC0, a public domain license, which essentially releases the materials out into the world. The question that I frequently got in this space is, well, what about citation? How do I get credit for my work? Fun thing is, citation has absolutely nothing to do with rights, legal rights, intellectual property rights. Citation, no part of that has been in any place. Citation exists because it is a norm within academia, that it's a social norm that we give credit where credit is due, that we track provenance of our scholarly ideas, and it has nothing whatsoever to do with copyright, licenses, or anything else. Where licenses come into play is when it is a term of the license that you must be given credit, and that's a little bit different, right? You should be citing your materials regardless of where you get them, regardless of copyright, regardless of licensing, regardless of anything. Just as a scholar, you should be citing. But licenses start coming into play when you have a license like a CC BY type of license in that space. And then it becomes a really interesting conversation, because you have to ask yourself, what are you trying to do with that legal requirement to cite? Is it something where you are going to track down that person if they do not cite you, if they do not give you credit? What do you have the resources to do that? What do you think the outcome of that is going to be? And that's one of the reasons I tend to recommend for most research materials is a CC0, release it into the public domain, because that legal overhead is, generally speaking, not that useful. However, there was a recent case against GitHub, Microsoft, OpenAI, a few other people in there around the coding issue, where they have created a generative AI, which does magic code for you. And I know I'm skipping over the technical stuff, but essentially it generates code for a particular coding problem. And a suit has been brought against the AI structures, because through the training model, all of these licenses have been stripped from the code. So people who released their code under a CC BY Creative Commons attribution license had the licenses stripped. They were not given credit. And these are the two of the major points of this legal case. So it'll be really interesting to see how that develops and how that ends up inflecting what we think about licensing things like code, like data within the research space. So something to keep your eye on there. And we can talk about exactly what that means when we start thinking about research materials being used by things other than humans, or other systems that weren't part of our conception earlier when we were thinking about these types of licenses. And perhaps it will inspire a new generation of licenses that takes AI and machine learning training models into account. And that'll be an interesting thing to watch for. So when you're coming to thinking about licensing, and I would still at this point encourage you to think about that, reach out to the TLO, think about CC0 public domain, but also keep in mind that licenses aren't so cut and dried. They can do a lot of different things. In the right legal hands, you can structure a license to do some really nice things for you. A lot of times when we create data sets, when we create research materials, we are to an extent altruistic. We want to see that used by other researchers to carry forward the research in that field, to see it built upon. We want to see how that develops. But at the same time, if it is discovered by a company, or if we would like to build our own company on it and think about licensing, that's a little bit different kind of structure that we're operating in then, right? That's a different kind of space. And the nice thing is that licenses can be structured in modular ways to accommodate multiple uses for multiple users. So, and again, this is something that TLO can help you out with in understanding what can be done, what should be done in your situation, and how you can use licensing to accomplish what you would like to see in the world when it comes to the materials that you have produced, when it comes to what your stakeholders' needs and desires are in these spaces as well. And this, includes everything from thinking about what are the aspects that you would like to have in place for commercial use versus academic or research use. How can it be distributed? How can it be modified? Do people have to disclose the source? Do they have to give credit? Do they have to give attribution? What are these? And you can see a bunch of these different aspects that are listed at the bottom of the slide. All of these different things are things you can think about doing in terms of what can be included in your license, what can be communicated through your license as you're thinking about releasing your intellectual property into these spaces. So sometimes things get even more complicated than you want to write up that very specific that license for, and there are very specific uses that a license just isn't going to cover. And this is really where use agreements come into play. So data use agreements, material use agreements, things like that. So in this space, we're really thinking about data use agreement and the common elements of data use agreements that you will often see are how the data can be used, what kind of publications can be written off of that research material, that research data. Uh, a lot of times you'll see data use agreements also in that space for very secure data or data that must be highly restricted. So you will see elements of inspection penalties associated with that if those requirements aren't met, along with legal details and other extras of administration. So for this use case, I went to the PSC, the Population and Social Data Center at University of Michigan, that has a catalog of data use agreements where they go through and say, for these 67 agreements, these are the 54 different conditions that are covered by these use agreements. So you can see in this space, data use agreements can get to some very particular conditions that wouldn't necessarily be appropriate to be managed by a license situation. And so if you are facing that yourself, where you're thinking about sharing your data with an individual research group or with an industry partner, and you really want to lay out these very clear conditions for use of these materials in that context, the data use agreement is a good tool for you to use that. So as an example, for some of these areas, these conditions that you can put into a data use agreement, you can say that it can only be used for statistical purposes. You can't do any re-identification. There can be one research plan, and you have to stick to the research plan. There's no creative going off in other directions. And like I said, this is often very useful for highly restricted data that's restricted because of the privacy concerns that we had talked about before. So data use agreements also come into play as a way where you can kind of erect a barrier within that bridging document that you're setting out. You do want to share, but you want to share under explicit conditions and under explicit controls in those situations. That's another nice tool. So for instance, around security, you can really see that there are a lot of examples about the specific security conditions that are written into that. Everything from you can only work on this data in this one office to you can't make any printouts of this data and what has to be done to the printouts if you are allowed to make any of those. So if you're looking at using a use agreement, I recommend that you go to the Office of General Counsel. They have some frequently asked questions. They have also put out a portal last year around non-disclosure agreements as well as data use agreements, and you can get help on either interpreting or creating those at the OSAT portal. So there's a resource for that there too. So we've pretty much covered, what are the barriers that exist around data, why there are useful barriers there, why we want bridges to our data, why those are useful bridges, and what are the legal tools, what are the tools that we have in our hands to be able to both protect the barriers that should be there, as well as enable the bridges that we want to when we think about the data that we produce and use, that we produce that research data. There are responsibilities, there are commitments that come along with creation of that research data, of those research materials, of that scholarly information that falls into the space of privacy, security, and we want to be able to manage all of those things effectively. And we can do that with legal tools of copyright, of licensing, and with use agreements that are available to you. So I've just talked for a long time without asking you any questions, and I feel very sorry about that. But I would like to open the floor up now for questions at this point in time. If you have questions about anything that we covered here, or any of the resources that are available to you, or a specific thing that you have in mind or an issue that you're dealing with as well. So please feel free to either put something in chat. Data can be patented. Are you asking if it can be? And thank you for the question, Jorge. And I think one of the questions in here is, I think that comes down to what is the type of data that we're talking about. So I know there are some patent structures which have allowed something like patenting a gene sequence, which under some interpretations might be seen as data. It's a research data, the gene sequence itself. And in that case, that organism has been patented in that space. Vital signs that I don't know about the vital signs that go to a diagnosis, whether or not that can be patented. I'd recommend that you take that to that's not an invention. So that's where I would have a little bit of caution around thinking about a patent structure in that case, because I think that tends to be more around creating an invention around that rather than just identifying which are the vital signs. But if there's an instrument that is detecting those vital signs, that might be something different. But talk to your technology licensing office about that. They'll be able to provide better clarity around it. Thank you. From Jordan. Oh, yes, absolutely. Run across this myself, Jordan, talking about data and things that are produced during hackathons. Um, I That's a good question. I have some, if you email data management services after this, or TLO as well, they might have some experience within coding hackathons. I know we have some people in the libraries who have been very involved with hackathons and thinking about the intellectual property around there. So we might have some resources for you there. I would say generally speaking, yeah, when you get people in hackathons, not everyone is operating within the same scope of understanding about ethics and rights and so on. It might be useful in those cases to have some type of pre-contract created and signed by people who want to participate in those hackathons, so that there's at least an acknowledged commitment to some of those areas. Any other questions? But yeah, I think the whole hackathon question is definitely a really interesting space and something that we've tried to deal with in the hackathons that we've hosted as well. And that kind of pre-statement of condition for participants, like you start out with a hackathon that, all materials that are produced during this hackathon will be licensed under the following, whatever your licensing structure is, whether it's a CC or like a new PL or something like that. Jorge, can you feel free to open up your mic and say a little bit more about your question, please, whether open knowledge is an illusion or that it really works?
Okay. I have worked in healthcare, and in many options, in my opinion, many people is looking for to develop solutions that serve a lot of people.
Mm-hmm.
But when you try to win money, the things become difficult. How can we deliver open knowledge?
Okay. So I think that's a great question. How do we effectively create and deliver open knowledge? And part of the question around that becomes as well, what are the other conditions that you want to assign to that open knowledge? And that's where it can start becoming complicated. I think there are structures that exist that definitely facilitate the delivery of open knowledge, and you can see those in the spaces of things like open repositories where people are putting all sorts of research information and materials in there freely available to anyone else. And I think that type of thing really does work because it also puts in place structures that support things like citation and provenance tracking for those who are interested in getting credit. So you do have that open knowledge, and you also have that opportunity for credit giving and credit taking in those areas. And I think it's thinking about those types of thinking about what we want to achieve when we're creating those platforms, their structures for what open means, as well as what knowledge means, and what are the other conditions around that open knowledge that we're interested in seeing that's going to support a sustainable structure of open knowledge. That goes back to thinking about how and why are people making their knowledge openly available, and how and why are people seeking out that open knowledge. So thinking about the needs of both the producers as well as the users in those space, and at the what is that at that base level. And that's part of what that initial FAIR acronym that I introduced tries to deal with, is that knowledge has to be findable. It needs to be in a mode that people can access and understand it, that it can work with other types of knowledge, and that knowledge is reusable, which sounds simple at the outset but gets more complicated as you think about how people might use that knowledge, how they might identify what is a useful bit of knowledge to them, and the work that it does take in order to really think constructively about that structure and about that space, how it looks, how it operates. So yes, if you want the easy thing, you take your research materials, you take your data, you describe it as well as you can, and you put it in a place like Zenodo, which is an open data, open research materials repository. And that makes the first step to saying, okay, I've taken the first step. But it really is just that first step in thinking about, when we talk about open knowledge, how expansive do we want to be? I don't know if you're familiar with the Open Knowledge Foundation. I think it's okf.org. AJ, I don't know if you could take a quick look, but they have what I found to be useful resources as well in thinking about how to create a sustainable open knowledge systems in those spaces. And that's, of course, before we start getting into the how do we create open knowledge that's also respectful knowledge. So it's one thing to be open, but we also want to be respectful to participants. Yes, I forgot a letter. Thanks, AJ. Who knows where you would have gone with the 3 letters I gave you. Does that help at all, Jorge?
Yes, thank you very much.
I mean, I think it's an ideal. I don't think it's an illusion. I think it's possible. It takes work, a lot of work. Time for one last question. And also, Jorge, I think there are ways we can use the legal tools to make open knowledge work as well. They're not just the barriers, they are those bridges. They are tools of communication that let people know they can use that open knowledge effectively and how they can use that open knowledge. All right. On that note, if you do have further questions, please do reach out to any and all of the resources that were mentioned today. And we would love to hear from you, whether that's talking about data management services, libraries, TLO. Stephanie's over here on my screen, so we have Stephanie over there. Thank you very much. And I hope you have a great rest of your day.
Thank you very much, Amy. This has been a very informative talk. And I think that there's maybe not many questions at the end because you answered all of them as you went along. So thank you for sharing your knowledge with us, and we appreciate having you.
Thank you again very much for the invitation. I've really appreciated the opportunity.
Yes. Have a wonderful day.
You too.
Bye-bye.